Lawyers of Reddit, what was your hold it moment where you knew you would win? Story 1. I had a client named Tom charged with battery. The alleged victim didn't really support the prosecution's case and in any event was reluctant to testify. They still had another witness though, and she said that my client was hitting the alleged victim, so it wasn't looking great. The prosecutor and I were talking before court started, hanging out by the courtroom doors when the witness walked in. She looked right at my client, who was sitting not 5 feet from me, then scanned the room and said, "Where is Tom?" The prosecutor and I looked at each other for a minute, and then he said he needed to check on something. When I saw him a few minutes later, he told me he was dismissing the case. Story 2. I knew the cops beat up my client and framed him. They described a knife in his possession that, quote, caused them to fear for their safety, end quote. Oddly, they never seized it. We won the criminal case and filed a civil rights case. While deposing one, he described the knife in detail. No more than 3 minutes later, he slipped up and claimed his partner told him my guy had a knife, but he never saw it himself. I told him that's not what you just said, and saw him panic. His lawyer panicked too and asked to see me outside. When we got in the hallway, I withdrew my settlement demand, and the case settled for a substantially larger amount within 45 minutes. Story 3. I had a client who was accused of taking a young woman's car and then crashing it and fleeing the scene. The girl testified at trial that she had given him the keys that night because she was drunk and would never ever drink and drive. Apparently, she was not aware that I had requested and obtained a copy of her driving record, which showed she received a DUI a month after the incident. I still remember the look on her face when I handed her driving record to her and said, "Except for that one time you got caught a month later, right?" The look on the judge's face was equally memorable. Story 4. I'm not a lawyer, but I took my old landlord to court when I was in college. They stole my security deposit because of childish claims, saying that I trashed the place, not knowing that I took pictures and video when I moved in and out. Their quote-unquote evidence was a VHS quality recording of going through a perfectly clean apartment in better condition than it was when I moved in. But then they opened up the top of the stove and found a single piece of elbow macaroni under it, holding it up triumphantly. That was the crux of their argument. The judge was not amused, and I got all my money back plus my lawyer fees and the filing fee. She then fought against her own lawyer to avoid paying him. Story 5. I was reviewing the transcript of an interview with a child. The child made incriminating statements against my client. At one point, when discussing the allegations, the child used an odd word, but I didn't think much of it. A few days later, I was watching a video of the child interacting with their grandmother, who hates my client. From about a week before that interview, the grandmother used the exact same odd word in the exact context the child later used it. At that moment, it became clear that the child had been coached. It was the first real aha moment of my career. Story 6. I was prosecuting a convenience store owner for luring a young girl who regularly came into the store back to a part of the store to touch and kiss her, child enticement. It was the only section of the store without surveillance camera coverage. They were in the back room for about 2 minutes and 17 seconds, per the timestamp on the videos. Of the many arguments the defense put on, one was there was no way there was enough time for anything to happen. In my rebuttal, on closing, I asked the jury to imagine what could happen in the room in that amount of time, and I asked them to all close their eyes while I timed out 2 minutes and 17 seconds on my watch, in silence. After about 60 seconds, 2 of the jurors started crying, knew it was going to be guilty right then. Story 7. It was my 3rd month of practice. I was in family law at the time, representing mom in a petition for a restraining order against boyfriend/dad. At issue in the broader case was child visitation, custody, support, etc. But today's hearing was just on the RO. We had pretty good facts, but it was mostly based on testimony of the parties. My client was way more reputable as witness, so I was feeling confident. 10 minutes before the hearing, my client shows up. I give her a last-minute prep on what to expect, and then she says, "I'm glad I'm going through with this. I can't deal with it anymore, and he's just getting worse." To top it off, he left me a drunken, ranting voicemail on Saturday. "You have your phone with you?" "Yes," she said. We play the voicemail, and it's a full 2 minutes of ex-boyfriend screaming lies like, "I should have killed you when we were together. You always acted like such a bratty child. I hope you burn to death in a fire." I didn't have time to ask her why she hadn't said anything to me about the voicemail before the bailiff called our case. We sit. The judge asks if either side has additional evidence, and I asked for permission to play the voicemail. Ex-boyfriend, who didn't have an attorney, didn't object, so I played the whole nasty 2-minute rant in open court. Judge goes, "We're going to take a brief recess before I issue my ruling. If the parties want to meet and confer in the hall, they are welcome to." Boyfriend knew he was screwed. We settled the whole case then and there. My client got her wish list in terms of custody, supervised visitation, child support, plus the restraining order to boot. Story 8. My favorite was probably a DUI where the cop was in Buffalo Wild Wings with my client watching a fight. Like the cop, was standing at the bar in the full uniform. Then when my client walked by him to leave, followed him out. Client was only actually going to his car to grab his phone charger and he hadn't even closed his tab yet. Cop arrested him and charged him with DUI for opening his car door, then fabricated the story for his report about how client got in car, turned it on, and began to pull out of the space to leave the parking lot. He also denied being inside the Buffalo Wild Wings, on the stand, under oath, to my face. Surprise, I talked to the bartender at Buffalo Wild Wings and got the security tape. It very clearly showed cops standing at the bar, watching my client walk out the front door, then follow him 30 seconds later. Parking lot cam also showed client barely touch the door handle before cops stopped him. Story 9. Not a lawyer, but was working as a paralegal for a law firm. We were defending a claim which had run into tens of thousands of pounds against our client, a holiday home, by a woman who had tripped over a speed bump while walking back to her caravan and damaged her knee. The fall was genuine. The question was whose fault this was. She claimed it was the holiday home's fault because she hadn't seen the speed bump due to low lighting, poor marking, etc. The claim had outrageously gone to months and made it to court. Going through the various questions to her, when our barrister asked how she knew the speed bump was poorly marked or something similar. Her response, well, I remember thinking how it wasn't well marked when I was walking up to it. Needless to say, it was a short day in court after that point. Story 10. My client was accused of brutally murdering a dog. Cop testified that there was no testing of the blood, no body ever found, and admitted it could have, in fact, run away. The eyewitness said she could see the killing down the hallway from the dining room. Cop testified there was no hallway and the dining room was on a different level of the house than the killing supposedly took place. Then the person who was leading the lynch mob against my client around town for the last year testified that she had been in the apartment between the two visits by the cop to evaluate the scene. No body, a compromised crime scene, witness who couldn't see anything, an admission that there was no proof the dog was dead. Closing argument lasted 3 seconds. Your Honor, I'm asking for an acquittal. Story 11. One of my friends got hit by a car when crossing the street, in a crosswalk, on foot. This was back when we were in high school. The guy tried to sue him for the damages to his car. At one point, the lawyer called up my friend's mom and asked for the son's insurance information and pictures of the damage of her son's car. She explained that my friend was on foot, and the lawyer just went silent for a bit. He said, I need to speak with my client, and hung up. He called back a few minutes later and told her that she wouldn't be hearing about this again. Story 12. A friend of mine was a DWI attorney in New York for a while. He was defending a guy who was asleep in the backseat of his car while intoxicated and an NYS trooper arrested him. On the stand, the trooper testified that he visually saw, quote, the key in the ignition. My friend gave him like 3 chances to walk it back. Are you sure, trooper, that you actually saw the key in the ignition? Yes, counselor. And then my body dropped the hammer. You are aware that my client drives a Toyota Prius? Bam. Story 13. We had no evidence that the woman who slammed into my stopped car going 85 miles per hour was drunk. She indignantly admitted it on tape in her deposition. She busted into my deposition and demanded she go first because I was, quote, a bold-faced liar, end quote. She excitedly told my lawyer that the police report was wrong because it said she was coming from the movie theater when she was actually coming from her friend's bar. Quote, did you have anything to drink at your friend's bar? Of course. How many drinks? I don't know. They just keep my glass full. Did you take any medicine that day? Methadone and low blood pressure medicine. I see. The cops had refused to breathalyze her at the scene because her husband was a firefighter that they knew personally. They told her to go home, sober up, and go to the hospital later. I heard the whole thing but had no proof until she handed it to me. They settled the same day. Story 14. We had a low-level thief in our courtroom who had robbed one of his neighbor's houses in the winter in Colorado, and all the police had to do was follow the footsteps back to his house, where he was hanging out with the stolen items and a small amount of drugs and a low-rate handgun. Idiot. Story 15. I was fighting for custody on behalf of the father, trying to prove that the kids were living in subpar conditions with their drug-addict mother in spite of the ample child support provided. It was a tough case because courts are so hesitant to pull kids away from their moms. Then the mom burst out that she had been feeding the kids cat food as proof that she wouldn't let them starve. Needless to say, the judge didn't take that as a good reason for the kids to stay with their mom. Story 16. When I was younger, I was being harassed by some debt recovery agency over money I didn't owe. Fees added to fees for a store card I had closed years before. I applied to have the debt set aside, which is basically where you challenge the debt recovery agency to prove you owe the money or lose the right to contact you about it. I turned up to court and the debt recovery agency didn't. The judge was so ticked off. She asked me to estimate how much the inconvenience of attending court cost me, and when I told her my estimate, around $600 with travel, time off, work, etc., she said, $1,200 seems reasonable. 2 weeks later, I got a check for $1,200 for refusing to pay some bogus fee. Story 17. Not a lawyer. I was a volunteer family advocate. I worked with families who were falsely accused of child abuse. I was contacted by a family whose children were in foster care because of parental drug use. The family claimed that they didn't do drugs and that no one would believe them. They had a court-appointed attorney who did nothing but tell them to stop using drugs. I honestly didn't believe them. I was pretty jaded. I told them to request their case file for me to review. I was surprised when they called me back and had the case file. I met with them and went through everything. I noticed claim of drug use, court findings of drug use, but no test results in their paperwork. I told them to ask for the results. Long story short, the caseworker wouldn't give them the actual results and the lab wouldn't either. So I drug tested them myself at a different lab. They tested clean. Color me shocked. There were 4 months to go until the next court date. Every time CPS drug tested them, they went right after to the other lab and did a second test. All clean. I told them to tell the lawyer beforehand that if CPS claimed any dirty drug test, to ask in court for the test results. He didn't want to. I was starting to get mad, so the day of court I had a stack of clean drug test results in my bag. The lawyer wouldn't even look at them, and he was openly hostile to my presence and involvement. Court starts. The CPS supervisor stands up and says that the parents have had 12 dirty drug screens in the past 6 months. The lawyer actually did ask her for the results. She said she didn't have them with her. I got the results out of my bag and handed them to the mom who was next to the lawyer. She tried to get him to take them, but he ignored them. I got so agitated that the judge said, "Mrs. Bays, looks like she's about to have a stroke. What's going on?" I stood up and explained that we had clean drug tests taken immediately after the mandated ones that the CPS claimed were dirty. I briefly explained that the parents had tried getting copies of the results and had been refused. I said that the parents had consistently denied even using drugs and had clean tests to prove it. The judge ordered CPS to provide copies of all the drug test results at hearing in a week. At that hearing, the case was closed and the children were released from foster care. The family never got an apology from anyone, but they were too traumatized to pursue it. They packed up and moved away within a month. Story 18. Bought a hurricane door from a contractor that was found through State's hurricane readiness website. He took $5,000 and after about 3 weeks of quote-unquote car or quote-unquote scheduling issues, finally just ghosted us. Took him and his company to a court. The him and his company part is important. Finally, court day shows up and I'm fairly young and in an optimistic, so I figure I don't need a lawyer. Plus, the local news station took my story and came out to interview me to do a bit on it. I figure it is a fairly obvious case, easy win. I put on my best $99 suit and head downtown. Dude doesn't show, but instead sent his company's officer manager. We get settled in with the arbiter, first thing I was wrong about. And the office manager starts in that they deny my claims and in fact are countersuing me for canceling the contract. I start to sweat. Quote, "You kidding me? They're going after me? What happens if they believe them? I'm going to be out $5,000 and have to pay them more?" The arbiter listens to her and then asks me to tell my side. I told him, plus showed documentation of what I had, did, and when. Arbiter, dude, looks at her and says, "He has enough to prove you wrong, but even if he didn't, because your boss Michael couldn't even be bothered to show up when he himself was specifically named in the suit, I'm ruling in the plaintiff's favor." Cue me trying not to happy dance or look too smug before I got out of that room. Side note, just because you win a judgment against someone, that doesn't mean you will get paid. You still owe me $5,000, Michael. Story 19. Not a lawyer, but I played one in a small claims court. My lease had an exit clause that said if I fronted 2 months' rent, they would work to lease my place and return anything unused. I checked with the office ahead of time. They ensured me there was a waiting list, so I gave them the 2 months and moved. They never returned a dime. I talked to the new tenant and confirmed they moved in a week later. In court, the judge was commenting on how he didn't see anything, explicitly saying they would return my unused rent, even though that intent was stated to me a few times. Dumbo from the leasing office piped in with, "Your Honor, in almost every case we can return some money, but in this case we didn't have a tenant in the 2 months after he left." So she gave the case back to me and I presented the affidavit from the new tenant confirming the move-in date. Judge awarded me double what they owed. Turns out leasing office Dumbos 1 and 2 thought they could lie to me and return my excess rent money to themselves. Story 20. My client was riding his motorcycle on a relatively calm street when this guy exited his garage without looking and run him over. In deposition, the guy brought a witness that was with him in the passenger seat the whole time. The witness maintained that my client was driving too fast and that there was no time to brake the car. I asked him the same question a few times in different ways, making him tell the story again. In the fourth telling, he already, a bit frustrated, let it slip. Look, I've already told you. We were exiting the garage and, as soon as I lifted up from getting up my cell phone on the car's carpet, wait, so you didn't even see the crash? There was no coming back from that. Story 21. I worked on a case involving defective processors. In discovery, we got emails from the defendant's engineers that had worked on the processors. They were in an Asian country, but the emails were in English because they were going to U.S. executives. One of the more senior engineers basically laid out the exact defect we were suing over, explaining what the problem was and why it was their fault, and finishing with, "This is a big problem. We ship crap to customer." Needless to say, we hit them over the head with that in mediation, and they settled shortly after. This was actually fairly recent. I was in a deposition of a fact witness to an automobile accident in which my client was killed. The defendant's attorney had called the deposition and over the course of an hour and a half or so, elicited a lot of testimony which seemed to place my client partially at fault, which would impact my client's financial recovery. After sitting quietly for an hour and a half, I asked less than a dozen questions, the last of which was about the specific location of my client when he had first seen them. Based on his answer, it was clear that my client couldn't possibly be at fault. I sent a follow-up letter that same day, and the case had settled within the next 2 weeks. Story 23. So I filed the lawsuit in January. We exchanged discovery. Each side sends questionnaires and gets carefully worded answers over the next few months. And I file a motion for summary judgment, meaning I'm asking the court to let me win in case without a jury because the case is so obvious. Right before I file this motion, I figure let's review the discovery materials and see if there's anything I missed. And what do you know? The other side made a massive mistake on literally just the fourth out of 100 plus questions that I asked. It's a dog bite case, and every single time I asked about the bite, the response is something along the lines of, "We admit to this and that, but we deny that our dog was involved in any dog attack." Well, question 4 asks whether they admit that their dog was not leashed on the day when it bit my client, and they simply answer, "Admit." Meaning they admit their dog was not leashed, and they admit that their dog was the one that bit my client. That was the one thing that was genuinely in dispute. They tried to argue at the hearing that it was a mistake and they only meant to admit to the lack of a leash, but the judge held them to their word, most likely because the other evidence made it clear it could only have been their dog anyway. For everyone hating on this for being misleading and the reason everyone hates lawyers, I'll clarify that at the time I wrote the questions, I would not have dreamed that they would have the balls to deny their dog's involvement. Their dog obviously is the one that did it. They let their dog out every day, no leash, and it terrorized the neighborhood for months before it finally bit my client. It was the only dog that ever did this, and yet the insurance company tried to lowball my client and refused to even cover their medical bills. So after 2 years of negotiating, they finally lawyered up. Story 24. My brother is a lazy do-nothing while also a doing everything wrong human that I don't associate with anymore. The dude has a lengthy criminal history and it pops up on traffic stops occasionally. So I was in court over custody of my oldest, and her mom's attorney was trying to paint me as a hypocrite for being an addict. I denied it all on the stand and he said, "Now James, I must remind you that you are under oath, and by denying this you are committing perjury." I stared him dead in the face and said, "My name is Bill. James is my brother." Even the judge laughed at him, and the only reason we didn't bring it up sooner was because I really wanted to know what he was up to with it all. Story 25. When I found a video on Facebook of the plaintiff squatting 300 pounds the month before his deposition, that was a good one. Oh, he was saying he couldn't work and he had back injuries after a minor car accident. I sent the video to his attorney. Afterward, the deposition in the case immediately went away. He also adamantly denied being able to work out or doing any lifting during his deposition. It was a big lie. Also, I agree that this really sucks for the people with legitimate injuries, who people quickly want to just label litigious. Story 26. Not a lawyer, but a client. In my divorce trial, my ex-wife had spent about 2 hours explaining to the court what a dirtbag I was and all the horrible things I had done to her and my children, and that I was unfit to be a parent. 2 solid hours, lie upon lie. Just 6 months earlier, my wife had snuck into my house. She's the one who moved out, and went on my computer to type me a love letter. "Oh, you're so wonderful. You're such an amazing father, great provider, great husband. You've done so much for the community. Please don't leave me." That's the gist of it. Well, she didn't print it or sign. It was just a file on my computer left on the screen for me to find. So our challenge, after all her testimony to the contrary, get her to admit she wrote this letter. I told my attorney, "Ask her. She won't be able to lie if she's sworn in. Plus, she's going to feel incredibly guilty about all these lies." So he handed her a printout. He had one too. He started reading it. He asked her, "Continue the reading." She started to cry. He asked her, "Do you remember writing this letter?" Her face was shriveling. She looked at her attorney and said, "I'm sorry, Sandy," her attorney's first name. Then she looked at the courtroom and said, "Yes, I wrote this." There was silence for a few moments. Then the judge said, "Attorneys, in my chambers, now." My attorney told me later, the judge understood that when your wife said, "I'm sorry, Sandy," that meant that her attorney was aware this letter might be brought up and that she had instructed her client to lie. The judge was furious. Back in the courtroom, my attorney went down the list lie by lie. Did he really do this? Did he really do that? When you say he was doing this, wasn't it really that? Etc. Then he had her read the entire letter again. After that, my divorce went from being half-inch away from losing all custody and relegated a supervised visits to I got full custody. Story 27. Years ago, I had to do something at a strip mall in a bad part of town. It took me about 20 minutes, and then I found that my car had been towed. Ubered to the tow yard. Giant sign says cash only. Had to call another Uber, drive to the ATM and back, and pay them 300 some bucks. Got a shady handwritten receipt that, believe it or not, was itemized. Went home, Googled, found that they violated the law in 3 separate ways: towed illegally, illegally refused to accept credit cards, and had multiple charges that the law called unreasonable, like dolly fees and load-unload fees. Took them to the small claims court. The judge began by asking the tow yard owner about the relationship with the property owner and how the decision was made to tow my car. "Oh," the slimy tow truck dude answered, "my cousin works there. If he says tow, I tow. It's 100% legal." The judge's eyebrows began to rise. "But what I detest the most, Your Honor, is the fool claiming I don't take credit cards. I'm a businessman. I take credit cards all the time. He's a lowlife that does not have any credit cards. That's why he wanted to pay cash." I was having a hold it overload, and the judge saw me smiling and hopping in my seat and patting my manila folder of receipts. "Do you actually not have any credit or debit cards?" the judge asked me. I pulled out my wallet and showed him, and then I pulled out a time-stamped photo of the cash-only sign I took the day of, and another one I took the morning of the hearing. The guy mumbled something like, "Okay, you got me there." And then he had nothing but, I don't know what that," when the judge asked him about the legality of each unreasonable itemized charge. Anyway, each violation pays double the total tow charge, and since there were 3, that's how I made $1,800 on a $300 investment. Story 28. I was drinking beers with my soccer team after a game in the parking lot in Flushing. 2 doofus rookie cops came to us and said they had to write us up. They were too lazy to write everybody up and just each randomly picked one to give a ticket. They said the rest of us could chip in. The ticket for open container in NYC is $25. But darn, I was in my first year as a lawyer, so I went with the 2 guys who got tickets to contest them. First cops didn't show up and the case was automatically dismissed. Second cop is there, as new as I was as a lawyer. I could tell the cop was nervous and new to all this himself. I just told the judge my client was drinking water out of a red cup and the cop didn't even bother checking it, which was 2/3 true. On the ticket, the officer had written that he was drinking beer from a bottle, which was only half true. The judge asked the cop in a fairly intimidating manner, "So what was it, a cup or a bottle?" The officer had stammered out, "Well, there were cups and bottles there." And that's how I spent a whole morning saving my team $50 to promptly spend on beer to drink illegally in public after our next game. Story 29. When I practiced insurance defense, I was handed a file to take over a slip and fall. Guy tripped on a hose, tore his ankle. The partner had taken the guy's depot already, so I read the transcript. I'm a Michigan football fan, watched every game for 20 years. This guy testified he was starting safety for a certain rival for certain years. Also that he graduated with a double major that doesn't exist at that school. I immediately knew this was false. Partner didn't understand. Dug deeper, lied about so much stuff unrelated to the fall for no reason. Eventually found high school records from football injuries of head trauma, knee injuries, and a slip and a fall injury a few months after ours. He also testified he rehabbed on ACL surgery after 1 month. Motion for fraud on the court filed, immediately settled. Story 30. Watched my lawyer have this moment last time we were in court. My ex abused my kid. I withheld visitation and hired a lawyer. I offered supervised visitation with a plan to integrate regular visitation once he completed anger management and parenting classes as well, as had 6 months clean of all substances. When he was on the stand, he mentioned that he had been taking prescription meds for 10 years. To illustrate that he's been on meds for a decade and never had a problem being a good dad. Lawyer asked what meds, and he listed off a bunch, meds like methadone, Klonopin, Vicodin, Oxycodone, etc. She asked why he began taking these particular medications. He replied, "Well, I messed up in the back last year riding my squad." She asked him to repeat himself. She said it again. The look on her face was amazing. She said, "So you've been taking large amounts of meds for 10 years?" She said, "Yes, 10 years of major medications due to an injury that happened 2 years ago. Judge agreed with my request for supervised visits pending the completion of this necessary step. X never completed any steps, and kiddo hasn't had to see him 4 years. Story 31. My client, the plaintiff, was in a huge car crash where my client's car literally caught on fire. During closing, the defense claimed that my client's shoulder spontaneously dislocated because it had done so 9 years previously. Previously, the defense expert conceded there was evidence that the crash probably aggravated her shoulder. The look on the arbitrator's face was priceless during the defense closing. After defense closing, but before my rebuttal, the arbiter asked defense counsel so many darn questions that my rebuttal was less than 5 minutes and solely on damages. The judge awarded 8 times the defense's last offer. Story 32. I represented an elderly Indian couple who didn't speak English very well and owned a rental property. They had a tenant at the time who had not paid rent in over 6 months. They had tried to evict her on their own, but when they got to court, the tenant produced some handwritten notes which they had given her the year prior thanking her for payment, but they failed to date the notes. Of course, the tenant added recent dates herself. The tenant also produced a partial certified check receipt, but most of it was illegible. Anyway, because of their poor English, they had difficulty understanding the questions and giving intelligent answers, so they lost the initial case. They hired me to help address all the various lies that the tenant was putting forth. Anyway, we refiled. I had my clients pull the banking records so we could show the date that the certified check was actually deposited into their account. The plan was simple. Let the tenant make the same arguments and then present the banking statements showing the deposit date. My clients also found a photocopy of one of their notes, but it was undated, unlike the copy the tenant presented the last time. Well, when the judge finally understood that the things the tenant had presented occurred the year before, his cheeks turned bright red and he asked the tenant, "What year did you make this payment?" The tenant started saying something like she couldn't be exactly sure when, and the judge cut her off again in a very loud voice. "What year?" Needless to say, the clients got the eviction granted. When the tenant arrived at court, I watched as she got out of her car, walked to the back and pulled out a wheelchair and proceeded to stay in the wheelchair until the case was over. Once the judge left the courtroom, she folded up the wheelchair and carried it to her car, mumbling, "I can't stand lawyers." Anyway, that was a very satisfying day. Story 33. I did a quid pro quo case for a guy who was doing my firm's website. It was a breach of contract case for a credit card. The debt had been sold, and at the time of trial, the addendum was something like $35,000. The client brought me in late in the game. He'd already gone to mandatory arbitration and lost. I got the case a week before the bench trial, and when going through the pleadings, etc., I realized that the plaintiff never sent 237 notice. This is when one side tells the other that they need to make available either tangible evidence or party witness at trial. Think subpoena, but less bite. So the plaintiff forgot to send the notice to the defendant that he needed to appear at the trial. Normally, if a defendant doesn't appear at a civil trial, you get the obvious. The judge only hears one side of the story and def loses. When a 237 is given and the defendant doesn't show, the judge is supposed to infer the def didn't show because his testimony would have hurt his case. But because this was on a debt buyer, plaintiff had no actual knowledge that this credit card bill and charges belonged to my client. All they get is a single-page printout from the original debt holder saying they sold this debt, and if they're lucky, some copies of statements. They could easily have proven it by calling my guy as a witness, even if client denies charges. Plaintiff can make a good case because defendant's name is on the bill. It's to his address, the restaurant charges are for the sub shop on his block, etc., and all that would come out when they call the def as a witness. So I tell my guy, wait down the street. We do pretrial motions and plaintiff asks for my client. I point out the procedural error and they panic. They put on their witness, who is some account rep at the debt buyer, and I object to hearsay on everything they try to get in. She has no knowledge, can't lay foundation for statements, and the only thing she can remotely testify is to her own business record. The single page slowing a debt sale. Not enough. Then plaintiff attorney gets a bright idea. He starts to ask his witness about the arbitration hearing. I see where he's going and let it play out a bit. He's trying to get an admission of party opponent. Basically, witness can say that the arbitration hearing, my client admitted this was his debt. But this is an out-of-town attorney. He doesn't realize that because arbitration is mandatory and he has very relaxed evidentiary rules, all evidence comes in if you tell the other side what you're going to use, that this country considers arbitrations to be the equivalent of settlement conferences, and the testimony isn't admissible at trial except to impeach. Directed finding for my client, who saved himself $35,000 judgment. Judge praises my defense, and I get to make super fake small talk in the tiny elevator with the plaintiff and his witness after the trial, where I walk out to hand my client the court order in his favor. Most satisfying win ever. Story 34. It was day 2 of a child custody modification trial. The opposition and her attorney were and are clinically insane. Their allegations were so weak that I told my guy, screw it, let's go for custody ourselves. I'm cross-examining Mom about her proposed custody plan for Dad in some detail, and I asked her, would you accept this for yourself? She snaps back, absolutely not. I ask, why not? Because I'm a mother. To his credit, my guy kept a straight face the entire trial and never once got annoyed. Her petition was denied outright. Ours was accepted by the court. If the mom or her lawyer hadn't been such pains to deal with, my guy probably would have agreed to some small reductions in his custody just to keep the peace. Instead, the judge just gave us nearly everything we asked for. Story 35. My BF's car was involved in an accident. He was parked in an area where during certain hours you were not permitted to park, as it would block semis from being able to maneuver to deliver goods, as it was a steel plant. A girl backed her vehicle in his driver's side door of his Ford Fusion. Cops were called for insurance purposes, and my BF states that it appeared to cop and the girl knew each other. They were on first-name basis. He received a parking ticket. It took forever for the insurance companies to sort it out because she didn't think she was at fault because she was parked illegally. That doesn't matter or make legal for you to hit someone's car and get off scot-free. She ended up having to pay for his deductible, and this is where the harassment from the local PD began. He received a piece of mail from our magistrate stating he failed to pay a parking ticket and a bench warrant would be issued if he didn't pay, or he could request a hearing regarding the ticket. He was just going to pay it. I looked over the paperwork and found that the vehicle they said he parked illegally was traded on before the ticket was issued. The ticket indicted a white Toyota Tundra, but the license block was not filed out. It was signed, but you could not make out the badge number. We had traded in his Toyota Tundra on a Ford Fusion in December. The ticket was written in February of the following year. I was pretty irritated. I gathered all the evidences for him, traded in paperwork, and he went before the magistrate. Cop testified that he saw a white Toyota Tundra illegally parked at a certain location, that he had a parking time restriction, and it was owned by my BF when he ran the tags. I should note that my BF had several parking tickets while he owned the Toyota Tundra. That is our guess on how we got just enough info to write the ticket. My BF presented his evidence and the judge dismissed the case. The judge was heard to say to the cop that he would like to speak to him afterward and chastised him for wasting the court's time. The cop later told my BF that he had contacted him. They could have taken care of it outside of getting the magistrate involved. Needless to say, we haven't had an issue since. Story 36. When I was about 4 years old, I was ill one day, and the only option my parents had was to take care of me was for my dad and to take me to work for him. My dad was an attorney, and work was the courthouse where he was arguing a case that day. My dad knew the judge and I were allowed to lay down on a bench during arguments from two attorneys present, dad and opposing counsel. I was a pretty well-behaved kid, and I guess I was quiet. I just sort of lay down on the bench and stayed silent. I have vague memories of the incident, but nothing really defined. As my dad tells the story, the judge grew bored, at one point, looking over to me, waved and gave me a smile, and commented on how well-behaved I'd been during all of this. Dad said it was all at that moment that the opposing counsel knew he'd lost the argument and subsequently lost the case. Dad joked about needing to take me to court more often. Story 37. And not a lawyer, but self-defended myself against an utterly horrible charge of using my cell phone, which was turned off charging, while driving. When the cop pulled me over and said it was because he saw me using my cell phone at a light, I told him that was impossible. It was turned off, and I would happily turn it back on and show him it hadn't been used in over 10 minutes. He refused to see it and wrote the ticket, $590. I was more than a little ticked off. I'll own up if I make a mistake. I once got a ticket for going 81 in a 60 zone that I thought was an 80. I didn't even fight because I was in the wrong, even if I wasn't knowingly speeding. But this was ridiculous. I didn't really think I had a chance, but hoped the cop wouldn't show. My luck, he did. And then the prosecutor showed me his statement. He lied and said I told him that I had just been checking my messages. Well, when he pulled me over and I told him I'd show him my phone, I took screenshots of my call list, my email account, and my text messages, all of which showed the time of the screenshot, and the last call email retrieval text sent or received. Judge let me admit them as evidence because his statement specifically indicated I admitted doing something relevant to the screenshots, and they of course proved that I had not used the phone of any of those things, strike one against him. Then when he testified, he said that he had seen me pull out my phone out of the cup holder, look at it, and put it back in. My phone was on a dash mount when he pulled me over, so I asked him about the cup holder and he said it was a dash mounted. I actually had a picture of the interior of my car because I thought maybe he'd seen me touching the screen of my car's controls. I drive a Prius, so I'd taken a picture of the interior. That, of course, showed the cup holders are not on the dash and instead are in a console in between the driver and passenger seats. Strike two against him. Finally, I produced my cell phone records and showed I owned an iPhone 6 Plus at the time of the ticket. I asked him again if he was certain I'd put it in a cup holder, and he said he was. He could hardly change his story at the stand. So I took a cup that was on the desk, in case people needed water during the trial. and set it on my phone in front of him and asked him to try to put my phone into the cup. 6+ phones are huge, and I used an OtterBox Defender. There was no way it would fit in a cup holder. He glared at me and said, "Well, the cup holders in my truck are big. It would fit in them." I reminded him the ticket showed I drive a Prius, and they are not a big car. Third strike. 3 times I proved that what he said could not have happened. The judge at this point interrupted and said I'd made my point, and did it very well. That was when I knew I'd won. And boy, was that cop fuming, but it was a glorious moment for me. Story 38. When I was interning at the criminal court for a judge, I observed a pre-trial hearing for a murder case. The defendant allegedly murdered his grandmother because she wouldn't give him money, then stuffed her in a closet and called a hawker for socks in the bed right next to the closet. Horrifying stuff. During the hearing, the defendant's lawyer, prosecutor, and judge went through some typical procedures. Then the judge asked the defendant if he had anything to add. The defendant smugly said, "Yes, actually, I don't think I'm mentally fit to stand trial according to Article 10 under the criminal procedure." The judge let him finish, looked him dead in the eye, and said, "The fact that you just told me this shows you're perfectly fit to stand trial." This brings us to the end of the video. Thanks for watching.